Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
Y'all, I know it's exciting. I know it's rejuvenating. I know any win builds confidence. It gives you the ability to want to keep pushing more and take on bigger goals and tasks and challenges. I understand that. So shout out to the people that are winning these, these little credit card cases. People who are winning on technicalities. People who are winning on them violating your FDCPA claims. Shout out to those who are winning, these little arbitration agreements. I mean, it's nothing wrong with them. A win is a win. But I know, like because I have an update from the live stream the other night, and I actually retrieved the case from Tempest Marine. Everything in the Supreme Elite Team University is how the system works. The good, the bad, the ugly. This is how the system works. And if you need any type of clarification to really know if I'm talking about, you can look at my receipts. Because I use practical law. I don't use pseudo law. I don't talk about common. I use practical everyday law that every attorney uses every day. I can scalp these people using the everyday law. I don't have to go back deep into the 1800s. I don't got to shout constitutional law. I don't got to challenge jurisdiction. I don't need to do none of that. They gave me the rules to play the game. And before I started playing the game on this level, I made sure I understood the rules to the game.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
Let me explain something to everyone. A debt buyer when a credit card arbitration for a credit card, nevertheless, those are wins. I mean, those are wins. I'm not gonna say they not wins. One of the common themes about these spaces and what separates my wins from all these other gurus is the wins that we get on my side. No disrespect, it over these credit card debt buyer technicality win overshadows them because the stakes are higher on my side of this game. You can win a credit card. It's not hard to win a credit card dispute, especially in a debt buyer case. And I don't want people to get the false sense of confidence that the tactics that they use in a debt buyer case, they're going to be able to use in a large automobile purchase case or mortgage case. The stakes are higher. And once again, on my side, I'm going to use me because I don't want anybody to feel offended. I don't wait to be the defendant. All in these spaces, everybody is the defendant. When is anyone going to be the plaintiff? Because when you're the plaintiff, you have to prove your case on the merits. You're not going to win by technicality as you can win as the defendant. When you actually know what you're talking about and your claims are on a professional level, your wins do not come by technicalities. They come by the merits of your claim, the resolving on the merits. And when your merits are ironclad like mine, more than likely, the case is going to result in a settlement. It won't even see trial in many cases. Maybe some outlier cases, But for the most part, it will be foolish for them to want to take the claims that we raise as the plaintiff in trial. I have a mortgage client. Guess what? When we file the lawsuit, if we can't resolve this issue behind the scenes, he's going to be the plaintiff. That makes a difference. Not only to be the plaintiff, he's going to be current on his mortgage by the time he files a lawsuit. So when you're current and you're the plaintiff, you have way more leverage. I'm not expecting everyone to duplicate me. Very rarely will you see a situation like mine with credit acceptance, how it went down. Very rarely you'll see that. It's okay. Very rarely you'll see that. When you send your documents to them via email and then they stop collecting on their own without a court order. And then you follow up with a lawsuit. Still, they didn't reinstate collection. So they stopped collecting. I filed it July, what is it? I made my final payment July. I sent the last payment to him and said, if you want any more payments, you got to meet me in the federal court. You got to meet me in the ring. Because I was already current up to that part. So I stopped paying. You know what happens when you just stop paying? And the only way they're not going to collect is you have to prove from a legal professional standpoint that you can proceed on the merits when you get to court. That's the only way, the way I can see it. And not only did they stop collecting, I filed the lawsuit August 25th. I sent them the email August 15th. I did not make August payments. Actually, I didn't make another payment after July 1st. And they took me off auto pay. They put the account on NA status. And then I filed the lawsuit. So from August to January 28th, no payments were made and there was no demands for payments. Everything was on hold. And then when they made their appearance, we went immediately to the settlement. We had conversations about they're going to try to invoke the arbitrations clause and all this, but it wasn't all the in-betweens of what I did, the motions I filed, what I put on the documents, my version of securitization, and my use of state law and federal law, and my citation of case law, and my strategic strategy on how to word things, understanding the nuances and the types of claims that are being raised. I'm not expecting everyone to have that outcome, because that outcome is less than what 3% of people are ever going to get from a pro se standpoint. Like, let's strip it all down and get to the reality. Do you always want to be having to defend against someone trying to sue you for non-payment? Is that really life? It's like let's look at it. No, I'm not trying to be funny. Do you always want to be in a position where you are not paying and now you got to find a way to get out of it? Or do you want to be in a position where you're raising the issue, you're on the attack, and in the end, you leave with the asset and the property entitled to it without having to pay and the account being zero? Isn't the object is to support your legal claims and walk away with the asset? I haven't seen pretty much nobody walking away with assets out at the end of the day. I mean, if we're just doing this to not be responsible for debt and credit card suing, because everybody named mama are to credit card, but I see very few people talking autos and mortgages because those are a very different ball game. And I understand, and Tempest Marie admitted, or Tempest Law response, depending on which day of the week it is, she admitted that she's not at that level to deal with mortgages yet. So she's staying in her lane. That's cool. But I'm talking about for you other so-called successful people. Your version of success is different from my version of success, because I don't want you to get it twisted. Like, with your like when y'all show me your little debt claims, your debt claim wins, like I didn't even have to go to court as a defendant to get this. I got this wiped away by just sending them a document. And autos and mortgages, because those are the two main assets that we're going to acquire in our lifetimes. Those are where majority of our bills will go. It's going to go to your mortgage, it's going to go to your car note. It's the two biggest necessities that we need today. We need transportation and we need a roof over our head. The stakes are higher in those situations because a lot is on the line. A lot is on the line. A credit card, you can win a credit card just by them not following through on the suit. You can win a credit card by them not showing up for a hearing. You can win a credit card or a debt buyer case just by them not having the proper documents and records. Like, it's not really hard at all. But even in a debt buyer case, let's say you win that, cool. You don't owe the debt anymore. But at the end of the day, how are you taking back your piece of the American pie? Because there's no title, no assets. What the reality is just a line of credit you got and you didn't pay it back and you found a loophole to get around the obligation. That mindset is not building generational wealth, as they like to call it. That mindset is not doing nothing for you, but let you believe that you can continue to do the same things you're going to get out of it. So the only thing you're really saying for real is, I'm going to get this line of credit on my face and then I'm not going to pay it back. And when they try to sue me, I'm going to use these loopholes. Even that won't work every time. But what I'm trying to say is all wins are not the same. Whatever they told you, they lied to you. They lied to you. No, I'm telling you, they lied to you. Let me just say that the way I look at wins is you getting the asset free and clear. And then you can do whatever you want with it. You want to transfer it into a trust? Because I see a lot of people online today still talking about transferring mortgages into a trust or putting the mortgages in your trust name and you haven't paid off the mortgage, or you haven't had the account set off to the point where you can transfer the mortgage or the property or the title into the trust free and clear. Most people try to assign the mortgage to their trust so they can have a third party interest to stage off and complicate the foreclosure proceedings. See, over here, when you transfer property into a trust after dealing with me, it's because you own it outright. And one of the things that they talk about in this space so much is how to get out of this, how to get out of that, how to get out of this, how to get out of that, how to get out of this. But what they're not talking about is true ownership, how to own things outright, how to walk away from the table, not owing a debt, but still keeping the property and getting the title to it. See, they don't want to talk about that. That's the only level that I'm on. If it's not that, I could give a rat's. I don't care about the own nothing but control everything. Let me tell y'all this, y'all. When people say that, they're taking the original term and meaning out of context. See, when they say own nothing but control everything, transferring assets into a trust, you know what the problem with that is, y'all? What was the Rockefellers? When they said the own nothing but control everything, what people want to skip over is they already own the assets before they were placed into the trust. Putting assets into a trust is a good legal structure. But when you don't own the asset that you're putting in the trust, the courts are going to pierce the corporate veil. It's not going to magically wipe the debt away. It's not magically going to wipe the tax obligations away. Actually, the trust pays way more taxes than regular individuals. Remember, in a mortgage, in an auto, it's not always so much about the title itself. It's about the security interest. That's all trust is really set up for, to transfer the security interest. When I have a security interest, or my accrual trust receivership has a security interest and legal rights to my truck, that means the trust has a superior lien, meaning creditors cannot pierce the veil because I legally assigned the asset to the trust, meaning there were no liens on the assets before I signed it to the trust. That meets the court standards, meaning creditors, agencies, they can't go after it for anything. And when the trust has the security interest, now the trust can pledge that title. The trust can make whatever moves is necessary for the benefit of the beneficiaries. That's how you play the corporate wealth game. It's not so much about the asset itself per se. In the corporate world, what every rich person understands, who are wealthy, who are successful, they understand that the right to receive payment is more powerful than the payment itself. Cash flows, consistent cash flows is more valuable than having $100,000 at one time. It's more valuable. So when you look at these securitization trusts, let's say they got about 50,000 in this pool. Say they got about 30,000 in this pool. They got 40,000 in this pool. They are creating receivables. Why do you think they don't mind letting you walk away with the house and vehicle right now, rather than you buying it outright? Because as long as they have you paying in monthly installments and got the contract that evidence it, and they have a security interest in the property and have a lien on it, they now have a license to print money. That's all what it is on the secondary market. It's a license to print money. So you still hear people talk about the Federal Reserve in our mix and the Federal Reserve in our business. I immediately know that they have no clue on how the system operates. Securitization is no different. I'm gonna use this analogy that I use in the Supreme Elite Team group. The securitization is nothing more than an extension of the game. All right, so you got the wholesale plug. He got all that stuff. That's the wholesale. That's where they go get the money. Now, there'll be banks that are set up just for the purpose of issuing lines of credit. Banks set up, or investors come pull all their monies, institutional investors, bam, right? So let's say they got 10 billion to lend out. So my Supreme Elite Team bank sits down with the acquisition corporation, like, hey, yo, so I bet we need about 500 million because we've already did the advertisement. People already know to come to the banks to get a loan. We already know that we don't have to go look for them. They're going to come to us. But if you look on our balance sheets, why would we want to use our own assets to fund these loans? It's too much risk. Hell nah. We're not going to fund our own loans off of their loans off our balance sheet. Why the hell? They may not pay. I bet. This is what we're going to do. We're going to go to the plug, right? We're going to get 500 on our face. And then we're going to originate the loans with the people. And then we're going to send it over to them. We're going to jack up the interest rates because, you know, we got to make a cut too. So that's just like, dude, the plug got selling me zips for $150, but I sell the zips to you for $50. So that's a $200 flip. That's $200. And then I deal with the people. So when I got it, when they need to pay me back, I deal with them so I can round out the money to pay the plug back. So the acquisition corporation gets the 500 M's, right? I bet out of this 500 M's. All right, hold on. Hey, plug, we gonna give y'all these mortgages. What type of mortgages do y'all want? All right, let me give you the professional. And if you hear anybody else say this, you know they got it from me, because the only way you would know is if you would know somebody that works behind the scenes. So let me tell you what was told to me, person that actually processes these mortgage payments to Fannie Mae and the investors. Oh, y'all gonna learn when I say I'm connected to professionals. I'm really connected to professionals. Y'all gonna believe me when I say it.
You're rocking with the best.
When I say I got them on speed dial, I'm not lying. All right, so when there's a minimum, so all right, the investors, they want credit scores between 620 to 720. If you get the 620, 650 range, we don't like to take those because it's more money and interest. If we get people with credit scores of 750 and 800, it's less interest. We really don't want them. Bet, we got you. A typical minimum credit score for a conventional mortgage in the U.S. is 620, while government-backed FHA may accept scores as low as 500 to 800, 500 to 580. Hey, we want people with credit scores between like 650, probably no more than 720, because when we get really 620 and 650, because when we get in those range, you know, that's more interest for us. That's the more we can get paid off it. We get credit scores like 720, 780, that much interest. So you can find people within that range that would be able to accept it.
You're rocking with the best. You're rocking with the best.
That boy is good. It's the minimum credit score. Exactly. It's Bank of America. 620. Like this. See, this is what I had to learn before I started teaching. Where all this goes. See how that? You see, when you see all these gurus, it'd be like 4 little flow charts, 4 little points in the Federal Reserve there. They took your money, took the application, gave you money off the... No, that's nowhere near how it goes. It has nothing to do with none of that. You got the transfer, eligible rates, receivable loans, loan obligors, services, loan agreements, eligible trades and receivables, servicer, periodic distribution of collectibles, conduit, and service providers.
Ladies and gentlemen, we are live!
I want y'all, let's see if I could do it like this. All right, now, I'm supposed to be debating Alan Najee. It's not my words, but I just doing this right now because the debate, when we have it, I would say when people want to debate you on something which you've already been successful on, I mean, it is what it is, but it really shows that the Dunning-Kruger effect. Not only that, I will say this. When you have real receipts and people don't want to believe or don't have the receipts to compare with yours, now they want to question your receipts. So Alan Najee's, his content is that, let's pull it up. My title that I just got based on the settlement says sedan instead of SUV. I have a SUV. This title is related to the SUV. Whether it says sedan or SUV, sometimes those could be clerical errors from the DMV. But the VIN number is what matters. When you run the VIN number on this title, it's going to match the VIN number on my truck. As a matter of fact, people in my group actually ran the title check. And people know my group. They know I had that truck for 2 years. They know what my truck looked like. But even still, even when you got receipts, even that gets questioned. So let's read. Y'all might want to pinch the screen because we're going to read along. He was going back and forth about his upcoming mortgage defense case in California. And I did tell him, for the people's sake, I hope he does win. But the way his arguments are framed and what he's trying to tell me, I don't think Alan Najee is going to win that mortgage case because I think he thinks he knows too much for his own good. So let's listen to this.
I'm gonna just try and break this down clearly to you. The trust in my client's case has been closed for 3 years. They cannot tie up any loose ends with that. Why? Because REMIC tax law prevents them from transferring any assets into the trust that aren't qualified mortgages and that are after the cutoff date and 90-day grace period for the trust. So they cannot tie up the loose ends. This is as clear as I could explain it to you.
And bibbity bobbity boo is y. Put them together and what have you got? Bibbity bobbity boo, x plus y equals y, x equals 0. The song is badly written.
And everything that you said has been argued before and overruled. You're speaking to the choir. When I was researching that, you were still a teenager. The question is, did the borrowers pay? Did they not pay? It doesn't matter who's enforcing when you're in default. Even if the trust is closed, they can kick it back to the lender and the lender has to repurchase it. So what if the lender repurchased it? Now it's their outright mortgage. See, you talking about the trust closed. It doesn't matter.
You're rocking with the best.
Context. I'm going to play what he said one more time, and then we're going to read this case.
I'm gonna just try and break this down clearly to you. The trust in my client's case has been closed for 3 years. They cannot tie up any loose ends with that. Why? Because REMIC tax law prevents them from transferring any assets into the trust that aren't qualified mortgages and that are after the cutoff date and 90-day grace period for the trust. So they cannot tie up the loose ends. This is as clear as I could explain it to you.
Remember when I said what you know has nothing to do with how you argue in court? And this is one of the biggest mistakes that rookies make when defending mortgages. They're always trying to tie non-court issues into a court issue. Tax remix, that has nothing to do with the obligation of the debt. It has nothing to do with enforcement. If they're violating the tax right, then the only thing that's going to happen to them is they're going to pay 100% taxes on the disqualified mortgages transferred into the trust. That's the only thing that's going to happen. They're going to pay taxes at the entity level on those mortgages. That's it. But somehow that's a legal defense. So forget what I said. Let's see if has anyone raised this claim before, and let's see how it fares. Because he may be on to something. But let's get into it. Remember I told y'all there was winning on the securitization arguments? All you had to do was just challenge an assignment and mortgages were being thrown out left and right. Remember when I told you what happens when everybody starts to do the same thing? They find a new way to shut those arguments down because the system can't take those many losses like that. Remember, the system always prevails. Like the judges, the courts, everybody knows that securitization and secondary market funds the bloodline of American financing. Without that, we have no economy. You know that, right? And this for all these mortgage gurus who get excited by pulling up cases from 2011, 12, 13, 14, like they're going to win on those arguments today. Let me see if I can. You died. I can't get his name right for nothing. Owned a residence in Los Angeles County. In February 2007, he borrowed $1,802,500. He borrowed $1,802,500 from Impact Funding and secured the loan with the deed of trust against the residence. Impact Funding is named as the lender and MERS as the beneficiary. The deed of trust provides that MERS is acting solely as nominee for lender and lender successors and assigns. And Yehudi's promissory note, together with the deed of trust, could be sold one or more times without prior notice to Yehudi. And y'all do know when you sign a deed of trust, you know they can transfer that as many times as they want. You know you can't. They don't have to inform you that they're doing it. It's just the new servicer and the new creditor. 29, 2007, Impact Funding sold Yehudi's promissory note and other promissory notes to a certain securitized investment trust, the ISA Trust. Deutsche Bank is the trustee of the ISA Trust, which is formed under New York law pursuant to a pooling and service agreement. Newsflash, all of these securitization pooling and service agreements are going to be governed under New York law. Why did they choose New York law to govern these pooling and service agreements? Because it's most favorable to the lender. In New York law, you definitely can't challenge defects in the pooling and service agreement. And New York is the money capital of the world. Now you see why they chose New York? Because you can't even bring up no pooling and service and defects, definitely not New York. You can't even bring that argument up worldwide anymore anyway.
The trust in my client's case has been closed for 3 years. REMIC tax law prevents them from transferring any assets into the trust that aren't qualified mortgages and that are after the cutoff date and 90-day grace period for the trust.
Like I'm not the teacher's teacher. The PSA, in order for a loan to be included in the ISA trust, it must be transferred into the trust by the closing date of March 29, 2007. So the closing date is the 90 days. So, and they get a little grace period between probably 100 days, 120 days, depending on the structure. So the day you close on your loan is the startup date for the trust. Within 90 days of you closing, according to their own agreements, the mortgages have to be into the trust. If it's not, from a tax standpoint, REMIC standpoint, it just means that they're going to get double taxed. It doesn't mean that you still don't have to pay. You notice how everybody is still using these things as methods to get out of a debt? Right now, this is what these are his words, not mine. More than 2 years after the ISA trust closing date, MERS as nominee for Impact Funding recorded an assignment of deed of trust purporting to assign to Deutsche Bank as trustee of the ISA trust all beneficial interests under the deed of trust together with the promissory note secured by said deed of trust. Footnote: respondents are Impact Funding, Mortgage, MERS, Deutsche Bank as trustee on a PSA related to Impact Secure Assets Corporation, Mortgage Pass-Through Certificate, Series 2007-2, and Bank of America. 2. A securitized investment trust is created by pulling the loans into a trust and selling to investors. The right to receive the mortgage interest and principals, aka the right to receive payment, aka receivables. My definition is in line with the judge's definition.
That boy is good.
The terms of the trust and rights and obligations of the parties are set forth in a pooling and service agreement. The 2009 assignment is dated as August 31st, 2009, signed on October 15, 2009, recorded in Los Angeles County on October 22nd, 2009. On February 12th, Deutsche Bank, as trustee for the ISA Trust, recorded a substitution of trustee naming Recon Trust Company in a Recon Trust, the trustee under the deed of trust. Once again, whenever you see that movement on the recorder of deeds with a mortgage, whenever you see a substituted trustee, you best believe that a foreclosure is imminent. The same day, Recon Trust recorded a notice of default and election to sell the property pursuant to a deed of trust. What did I just say? Whenever you see a notice, that movement, that changing substitution of trustee, what did I say? A foreclosure is imminent. What happened on the same day after they substituted trustee? Same day. I told you, bro, I know this stuff like the back of my hand. 3 months later, Recon Trust recorded a notice of trustee sale. On June 15, 2012, Recon Trust conducted a trustee sale, sold the property to Deutsche Bank as trustee for the ISA Trust. In his second amended complaint, Yahadi alleged that the 2009 assignment is void because it occurred after the ISA's trust closing date, and that Deutsche Bank's and Recon Trust actions, including the trustee sales, are void because they are derived from the void 2009 assignment.
The trust in my client's case has been closed for 3 years because REMIC tax law prevents them from transferring any assets into the trust that aren't qualified mortgages and that are after the cutoff date and 90-day grace period for the trust.
He asserted causes of action for negligent misrepresentation, slander of title, fraud, quiet title, and declaratory injunctive relief, in violation of Business and Professional Code section 17,200. Yahadi sought damages and equitable relief, including orders nullifying and rescinding the foreclosure sale, cancellation of notice of default and trustee sale, and judgment quieting title to the property. The trial court sustained the respondent's demurrer to the entire pleading without leave to amend, and thereafter entered a judgment of dismissal. In his second amended complaint, Yahadi alleged that the 2000 assignment is void because it occurred after the ISA's trust closing date. Najee Allen, he's in California. California Supreme Court case. Appellate court case. And represents that his claims depend on his alleged allegation that the 2009 assignment is void. Based on that representation, in the absence of relevant arguments, we do not consider these additional allegations. One of the biggest mistakes that you never make in court. And this was a lawyer that made the mistake. This is one of those fly-by-night lawyers jumping on the securitization wave. If you don't raise it, what do I say in the group? You wave it. I told you, y'all, this is not for everybody, y'all. I teach the 2% stuff. I teach the 2%. And this is why many people with the 2%, this is why many people, when I say many people, will not win. You won't see a title in their name anytime soon. We treat the demurrer as admitting all material facts properly pleaded, but not contentions, deductions, or conclusions of fact or law. We also consider matters which may be judicially noticed. Further, we give the complaint a reasonable interpretation, reading it as a whole in its parts in their context. When the demurrer is sustained without leave to amend, we reverse if there is a reasonable possibility that the defect can be cured by the amendment. Yahudi's contention that the 2009 assignment is void This is the hallmark of all these gurus' arguments today regarding mortgages and the securitization of them. This is the hallmark of them. Every single guru online today is going to make this argument. Besides me, Hudai's opening brief on appeal, he acknowledged that the viability of his claims, as well as the proposed new cause of action for wrongful foreclosure, turns on his ability to challenge the 2009 assignment. This challenge is based solely on the premise that the 2009 assignment is void because it occurred after the ISA trust closing date establishing the PSA. Our Supreme Court addressed contention, a similar contention in Ivanova. Remember, Island, when I was like, you sure you got cases post Galaski that says the same thing? You sure? I didn't tell him this case because this kills Galaski. This case right there, Ivanova. We went over that case in my master netting class. This case kills it. In that case, plaintiff secured a loan with a deed of trust against her property. As in the present case, the loan was sold to Deutsche Bank as trustee for an investment trust. I thought securitization was illegal. I thought securitization was so illegal. I heard gurus keep saying securitization is illegal. I'm not going to play the semantics word games with legal or lawful, but I thought they said securitization was illegal. The court's not saying it's illegal. The courts keep making references to it. Under the terms of that trust, the closing date for the transfer of loans and deeds into the trust was January 27, 2007. Almost 5 years after that date, in December 11, 2000, the plaintiff's lender executed an assignment of the deed of trust to Deutsche Bank, a trustee of the investment. Deutsche Bank then caused plaintiff's property to be sold at a foreclosure sale. The plaintiff in Ivanova alleged that the assignment of a deed of trust into the investment trust was void because it occurred after the investment's closing date. The trial court sustained a demurrer to the complainant, and this court affirmed. The Supreme Court reversed and held that the plaintiff could state a cause of action for wrongful foreclosure if the assignment of the deed of trust was void and not merely voidable at the behest of the parties to the assignment. Explained that only the entity holding the beneficial interest under the deed of trust, the original lender, its assignee, or an agent of one of these, may instruct the trustee to commence and complete a non-judicial foreclosure. None of that says borrower. If a purported assignment necessary to the chain by which the foreclosing entity claims that power is absolutely void, meaning of no legal force or effect whatsoever. The foreclosing entity has acted without legal authority by pursuing a trustee sale, and such an authorized sales constitutes a wrongful foreclosure. Meaning, if the parties to the agreement says, nah, this is void, nah, kick this back, we don't want this, nah, there's too much defects, send it back, and they still go sell it, then yes, the assignment's void. But none of that hits to a borrower's right to assert that argument. None of it. The Ivanova court did not give the borrower the right to assert that argument. We know. It's a hard pill to swallow. I know what they really want, y'all. They want a humble teacher. They want a teacher who's going to be soft and tell you the sky's going to be blue every day, and you're going to win even when all the evidence points that you're going to lose. And when you lose, it's not your fault. It's the system's fault, because they don't want to be exposed and they don't want the truth out there. That's what happens when they lose. It's the system's fault. It's not your fault. You didn't study. You didn't interpret case law correctly. No, that wasn't an issue, that you don't understand the court rules. You don't understand rules of evidence. You don't understand securitization like you think you do. You don't understand the nuances and complexities of mortgages. No, it's because they don't want
securitization to be exposed.
An assignment that is merely voidable, by contrast, does not support a wrongful foreclosure action. And 99%, besides the Supreme Elite Team University, everybody else out there who is making these arguments, the assignment is merely voidable. California law, the Ivanova court explained, does not give a party personal standing to assert rights or interests belonging solely to others, aka the investors. When assignment is merely voidable, the power to ratify or avoid the transaction lies solely with the parties to the assignment. The transaction is not void unless and until one of the parties takes steps to make it so, meaning the investors had to instruct the trust manager of the trust to say, nah, void this. It's the only way it's void in California. A borrower who challenges a foreclosure on the ground that the assignment to the foreclosing party bore defects, rendering it voidable, and thus be said to assert an interest belonging solely to the parties to the assignment rather than to herself. See Osco Galaski versus Bank of America, which Mr. Najee wanted to cite as well. Who died is such a borrower. Say it again, Judge. Who died is such a borrower. Significantly, the Ivanova did not consider or decide whether the assignment of the plaintiff's deed of trust to the investment trust after the trust closing date rendered the assignment void and not merely voidable. That question was a matter to be determined after remand. And guess what? They still ain't touch it because they can't touch it. And Ivanova still lost her house because they can't touch that. So that argument, Chavalino, the courts are not going to invalidate it. Want to know why? Because millions of assignments take place worldwide after the closing date. And remember when I said, when you fly too close to the sun, you get burnt? You know what that means? You cannot pass a law that is going to invalidate every normal day practice on the secondary market. It's not because it's right. It's not because it's wrong. It's because we represent a subset of American people. The average American does not think like us. They're not interested in fighting. They'd rather pay their bills. They're going to go to these people for loans and they're going to pay their loans back. They're not taking this role. So there are millions of people who rely on the same system that most people out here are trying to destroy. So they're not going to touch that argument because I can find 1 out of every 3 securitization trusts who has a late assignment. That is the normal practice. They're never going to do it all on time. But the courts are never going to make a distinct ruling on it because it's going to jeopardize the overall system. The system always wins. Picture is bigger than your anecdotal current situation. When you fly too close to the sun, you get burnt. His Second Amendment complaint, you see how they just skip right over that? Whether the assignment into a trust late was void and not merely voidable, it was decision to remand on demand, and they still ain't touch it. You notice how this court ain't touch it? No court is going to touch that. Udai alleged that the 2009 assignment is void under New York law, which he alleged governs the ISA trust because it occurred after the closing date specified in the PSA. He asserts that under Ivanova, the allegation is enough to survive the murmur. We disagree. Although we must accept the truth of Yehudai's factual allegations when reviewing the ruling on the demurrer, we are not required to accept the truth of his legal conclusions. And that is what many mortgage gurus can't understand. Your truth, knowing what happened, knowing the closing dates, none of that matters in court. We disagree. We are not required to accept the truth of his legal conclusions. Remember I said they like to make legal conclusions? Instead of making your claims and throwing it up in the air and let the judge finish the alley-oop. Hey, judge, we feel went like this. And the judge is like, well, damn. Yeah, it couldn't go any other way. I see what you said. But many teachers are going to make legal conclusions. In opposition to the demurrer, Hudai relied on Galaski, the same thing Alan Najee keeps posting, to support his assertion that the 2009 assignment is void. In Galaski, the plaintiff's loan was pooled with other loans and transferred into an investment trust formed under New York law. Like Hudai, the plaintiff alleged that the purported assignment of his note in deed of trust to the investment trust was ineffective because the assignment was made after the trust closing date. To determine whether there was a legal basis for concluding that the trustee's attempt to accept a loan after the closing date will be void as an act in contravention of the trust document. The Court of Appeals looked at a New York statute which provides if the trust is expressed in an instrument creating the estate of the trustee, every sale, conveyance, or other act of the trustee in contravention of the trust is void. Quoting New York Establishment Powers and Trust Law, Chapter 7, verse 2.4. In applying this statute, the court relied on a then recent decision by a New York trial court, Wells Fargo Bank versus Irobobo, another case that I've read, which involved a mortgage that had been transferred into an investment trust after the trust closing date. The Irobobo one court stated that acceptance of the note and mortgage by the trustee after the date the trust closed would be void. Based on Irobobo 1 in a bankruptcy decision that followed Irobobo 1, Galaski concluded that plaintiffs' factual allegations regarding the post-closing date attempts to transfer the deed of trust into the investment trust are sufficient to state a basis for concluding the attempted transfers were void. And I told Alan Najee, you're relying on Galaski, but I'm telling you, we're not in the age of Galaski anymore. And he was citing me all cases in which I had case law after the dates of those cases to invalidate. It's all about the current case, not the prior case. After Galaski was decided, a New York Intermediate Appellate Court reversed Irobobo 1 in rejecting the trial court's view of New York law. The higher court explained that the borrower in that case was a mortgagor whose loan is owned by a trust, does not have standing to challenge the mortgage assignee's possession or status as assignee of the note and mortgage based on purported non-compliance with certain provisions of the trust. See, the difference between me and everybody else that calls herself a teacher, I utilize this stuff for my own self. The trustee of the investment trust in that case was thus entitled to summary judgment on its action to foreclose the mortgage. This is post-Galaski, which Galaski relied on Irobobo. So if Irobobo failed, Galaski falls by the wayside by default. Subsequent cases have consistently rejected Irobobo 1. Want to know why? Because the system is too big. Hundreds of millions of mortgages are assigned to trust after the closing date. You think they're going to shut that down? In reference, Jepson, 7th Circuit, 2016. New York courts consistently have held that an assignment that fails to comply with the terms of a trust agreement is merely voidable and not void. Corcroft, HSBC Bank, reject the borrower's reliance on Irobobo 1 in light of reversal Irobobo 2. Ferguson vs. Bank of New York Mellon, 2015. Based on Irobobo 2, courts construed New York law such that violation of a PSA would render challenge assignment of deed of trust at most voidable, but not void. Rajaman vs. Deutsche Bank. Under New York law, unauthorized acts of trustee and investment trust were not void, but voidable. Butler vs. Deutsche Bank, 2014. Even before Irobobo 2, the vast majority of courts to consider issues have rejected Irobobo's 1 reasoning, determining that the acts of a trustee in contravention of a trust may be ratified and are thus voidable, meaning they can correct the mistake. Salvador Supra, in contravention of any trust ratified. The bankruptcy court case Galaski cited has received similar negative treatment. Rizovskaya vs. Deutsche Bank, August 1st, 2014. Kufos, U.S. Bank, 2013. Henry Stantonworth, Eastern District of Virginia, my district, bankruptcy, 2016. I told you, When many people start winning on the same argument, they all huddle up and find a new way to shut it down. They gave everybody 2011, 12, 13. They gave everybody 3 years. Starting 2014, they said, nah, that argument is dead. I told you. See, I followed the procedural posture of each court in each district, and I started to see the turn in 2014. From 2011, 2012, 2013, I said, okay, everybody's spanking on these arguments. Once I got to year 2014, I said, uh-oh, too many people are starting to win. Uh-oh, too many people are starting to win. Uh-oh, they done changed it. Like, I do this in real life, not online. I reap the benefits of what I teach in real life. Ain't no better feeling than putting in that hard work and walking away debt erased, entitled to the asset. Oh, man. All because you understand how the system works. The rejection of irrevocable 1 is based on sound reasoning. Under New York law, unauthorized acts by trustee may generally be approved or ratified by the trust beneficiaries. Remember when I said, why do you think they use New York trust law? Under irrevocable 1, however, a stranger to the trust will have standing to assert that the unauthorized transaction is void, thereby giving the stranger the power to enforce with the beneficiary's right of ratification. The stranger's right under irrevocable 1 to declare transaction in void would thus conflict directly with the beneficiary's right to ratify the transaction. This conflict is avoided by rejecting irrevocable 1 because a trust beneficiary under New York law retains the authority to ratify a trustee. Ultra vires act, such as a late transfer, the act must not be void. It must merely be voidable.
The trust in my client's case has been closed for 3 years. They cannot tie up any loose ends with that. Why? Because REMIC tax law prevents them from transferring any assets into the trust that aren't qualified mortgages and that are after the cutoff date and 90-day grace period for the trust. So they cannot tie up the loose ends. This is as clear as I can explain it to you.
No, you ain't got to explain it to me. You got to explain it to the judge. Because the decision upon which Galaski relied for its understanding of New York law has not only been reversed, but soundly and overwhelmingly rejected. We decline to follow Galaski on this point. Uh-oh, Alan Najee, because you're relying heavily on Galaski. Uh-oh. Standard Bank versus JP Morgan. Rejecting Galaski because New York case law upon which Galaski relied has been overturned, which I tried to explain to you, Alan. Galaski has been shot down. Based on the authorities cited above, indicate a post-closing assignment. A post-closing assignment of a loan to an investment trust that violates the terms of the trust renders the assignment voidable, not void under New York law.
I'm gonna just try and break this down clearly to you. The trust in my client's case has been closed for 3 years. They cannot tie up any loose ends with that. Why? Because REMIC tax law prevents them from transferring any assets into the trust that aren't qualified mortgages and that are after the cutoff date and 90-day grace period for the trust. So they cannot tie up the loose ends. This is as clear as I could explain it to you.
You're rocking with the best.
Our Supreme Court's decision in Ivanova approved of Gaski's holding that a plaintiff has standing to assert a cause of action for wrongful foreclosure when a purported assignment necessary to the chain by which the foreclosing entity claims that power is absolutely void. That means only the investors, the beneficiaries, can render it void, not the borrower. The court stated, however, that Galaski's further holding that the assignment of a deed of trust to an investment trust, to an investment trust was void because it occurred after the investment trust closing date was not before the court. The court and it expressed no opinions as to Galassi's correctness on the point. They're not even going to touch it. The reversal of Irrevocable 1 and the judicial response to it occurred after Yuhade filed his second amended complaint in his opposition to the debarment. Yehudai now contends that New York law is irrelevant and has no role in this case. Oh, you was just citing it. Now it don't work no more. It's irrelevant. He points to a choice of law clause in the deed of trust, which provides that the deed of trust is governed by federal law and the law of the jurisdiction where the property is located, i.e. California. Even if this clause governed the question whether the assignment is void, Yehudi offered no citation to federal or California authority other than Galasky to support his assertion that the 2009 assignment is void because it was made after the ISA's trust closing date, because you're not going to find a case after Galasky. That's the whole point. If you were before Galasky, that's that 2011 to 2013 wave where you won on those arguments. When 2014 hit, nobody wins on those arguments anymore. But hey, I don't know what I'm talking about. I don't know what I'm talking about. I'm just a person who has already been successful in a non-judicial state. Already been successful in a non-judicial foreclosure. That's all who I am. But besides that, I don't know nothing else. Mr. Najee, I've already been successful in what you're trying to accomplish. But I will give you some advice. I didn't make none of the arguments that you plan on making. Therefore, we reject it. Arguments made without reasoned argument and citations to authority may be treated as waived. Y'all know what that means? When you just bring your claims, but you have no case law to back up your assertions, that should be an indicator that a lot of these sovereign citizen arguments have no merits. Okay, let me tell you this. If you make an argument in court, but you have no case law or authority to back up your argument, it doesn't mean nothing. You haven't stated no claim. When I raise arguments, like when that mortgage, I probably raised about 13, 14 arguments. I had case law to support all 13, 14 different arguments. But it also contains that he should not have to prove that the assignment is void. Why? That's your whole argument. Now contends he should not have to prove the 2009 assignment is void. The respondents, he argues, should bear the burden of proving the validity of the 2009 assignment. And that's the problem. You never look for the other side to prove your claim. You're the plaintiff. See, when everybody doesn't want to be a plaintiff, they got to be defended. When you're the plaintiff, you got to prove every single case, every single element of your case be 100% spotless in order to win as a plaintiff, especially pro se. The arguments I raised with credit acceptance, you see those in class action, securities, and investor lawsuits. You would never see those arguments as a pro se. No one puts a complaint together like me. Pro se, no one does. He cites the cases in which a plaintiff purporting to be the assignee of a contract right had the burden of proving it actually held the contract right it was suing to enforce. Rockefeller's Title, Neptune Society. Here, however, Deutsche Bank has sued no one. Yehudi, as the plaintiff is challenging a non-judicial foreclosure, has the burden to prove it was wrongful. I just said it. You're the plaintiff. And this is why only the select few are ever going to be the plaintiffs and succeed. When you're the plaintiff, you got to prove it. It ain't like being a defendant in the credit card debt case and you win by they didn't show up to court, or you went by a technicality, or they just dropped the case because they don't want to waste the time and money. The debt ain't really worth much. They was probably hoping you'll get a default judgment, some like that. But when you're the plaintiff in a mortgage case or auto case, and you especially take them to federal court, the federal courts are strict. You best believe that federal judges are very sharp and they're very strict by the rules. And the reason why a lot of pro se people don't win in federal court at that is because they don't follow the rules. Are very strict. Now, you'll get your motions liberally construed as pro se, but you're not going to get exemption from the rules. If you do not know the court rules, do not step into a court. California law does not support Yuhidi's claim. As even not cited, the deed of trust is inseparable from the note it secures, and it follows it even without a separate assignment. You know what that means? You know what that means? There's no need for the wet ink, note, signature. They don't have to. Whenever the note is signed, the deed of trust follows with it. I assigned the note to Justin. The minute I assign the note to Justin, the deed of trust follows it automatically. That's how courts start treating it now. So remember that 1854 Supreme Court case? You can't bifurcate the note. They separated the note from the deed. Yeah, that's in the early 1900s. Now, when I sign the note, the deed automatically follows. See, but they would know that. They read case law. It just says it right here. California, the Informational said the deed of trust is inseparable from the note it secures and follows it even without a separate assignment. See, this is where we get to. This is where people's arguments start to fall apart. What they believe is true starts to fall apart. And I know people that work behind the scenes on this stuff. So we have an advantage over here because we're going to be privy to a lot of things that the average pro se litigant would just never be privy to because they're nowhere near in that world. I'm closely connected to that world in real life. Hey, what's up, partner? Hey, I just have a quick question. The brother for Fannie Mae, right? I want us three to get on the call. I want to see if he can make an appearance with at the Supreme Elite Team University. I want to see if just like 15, 20 minutes of his time. If he just make an appearance.
Okay, cool.
All right. It starts Friday, but we'll do it for probably the second or third week. We'll do that as a I want to talk to him before so I can have that as the like a special guest type situation.
Okay.
All right.
Okay,
yeah, and the only thing we're just going to discuss the behind the scenes, just with the just the little transfers of the notes and the payment structures to the investors. That's all. Just a little.
Okay.
I bet that.
Cool.
Yeah.
Cool. Yeah,
So just let them know. We can all get on the three-way and go over the parameters. So just be a speed dial away. Yeah, it's just.
Jeff Campbell.
Mr. Gamble, how you doing, sir?
I'm doing well, thanks.
This Lamont Thomas.
Yeah.
Hey, nice talking to you. I just wanted to let you know personally, I appreciate your help with the matter of resolving this with credit acceptance. I did receive the title. I appreciate the fast expedition on that, but just wanted to give you a thank you, man. I appreciate your hard work, man.
No, I'm glad we were able to work it out.
Yes,
and you were a big part of that process too. So
yes, most definitely.
Just sit for a bit, and the momentum when really people are working towards the goal.
Yep.
Really helps.
Yes, sir.
The process.
Yes, sir.
I too am thankful for your role in that as well. But I really appreciate the call.
Yes, sir. Yeah. Maybe one day we could go head out to a restaurant and I can just pick your brain a little bit, man, because your record is an exceptional, man. Now, for real, your record is an exceptional, man. For real. I follow a lot of your work, man. You're exceptional. I give you credit, man. So maybe we can do that some other time, right? Off the record or something.
Appreciate that offer.
Yes, sir.
And those words.
Yes, sir.
It was nice working with you. Really
all right. Thank you, Mr. Gamble. I know you're busy, man. I'll see you later, man.
All right. Thanks very much. Take care.
All right.
All right. Bye-bye.
That was the attorney for credit acceptance.
You're rocking with the best. You're rocking with the best.
A seasoned class action litigator. He's a seasoned class action litigator. He's a litigator for real, Jeffrey Gamble. Seasoned class action litigator. Oh, the connect. I build connections everywhere I go. I build connections with elite professionals everywhere I go. How do you do that? You're just a regular. Because I understand the game and they understand that I understand the game. So when you understand and know the game, you get treated differently. Instead of coming with, where's the blue wet ink signature? It's fraud. They took my home. And when you get to settlement, you're not trying to, I want money. I'll settle. I want the proceeds for the note. I want the security. You don't understand professionalism in settlements and how the business works. And knowing that if you ask for money instead of the asset, they're going to fight and say F you because giving money is akin to admitting guilt. They don't ever want to admit guilt. This is why I propose that no admission of guilt on both sides. That's what made credit acceptance way more than settlement. Because one thing, when you get on professional status with it, you have to protect the same system in order for you to get what you want. That's how the game goes. Call me a sellout or what, but that's how the game goes. And I'm not here to rewrite the rules to the game. I just follow protocol. And that's how you win. I played a big role in my settlement. I could have forced them into a fight and won. I could have forced them, but why? Is that really the right thing to do? Why over push? You know you got them dead to rights. Why over push? Don't they offer times to settle with you? Hey, you're severely behind, but we'll settle this for this. Don't they offer chances to settle? What's the bigger goal? Trying to expose some, extract money out of them? Or play the game to win? There's always going to be opportunity to get money out this. But when you start chasing money in this as your only sole goal, you always end up chasing your tail. Thus, if the note was timely conveyed to the ISA trust, as Yahadi alleged, so was the deed of trust. Although the conveyance of the note may have been separated in time from the execution, recorded and physical transfer of the instrument reflecting the assignment of the deed of trust, the gap does not alter the legal fact that the deed of trust and the right to foreclose was, as a matter of law, transferred along with the note. U.S. versus Thornburg, 9th Circuit, 1996. Even if a party holding the deed of trust instrument fails to hand it over to the note holder, has the right to like I said, the bifurcation, the deed of trust must follow the note. Those are old, outdated arguments. Mendez versus D1 Investments, 2005. Fontenot versus Wells Fargo, 2011. And you know what I think? You know what the Fannie Mae, the one that works on behalf of the investors, that processes the payments to the investors, deals with the collateral agent, deals with behind the scenes. You know, I asked him a question. I said, hey, I'm going to ask you a question. This is what I believe. This is what I researched. This is what I think is true. I said, the deed of trust is BS. It's hot air. It's a smoke screen. It's the note that really is the real deal, ain't it? He said, you are absolutely right. The deed of trust ain't nothing but a piece of paper. It's the note. And it's a guy that works behind the scenes with him. And that's what I figured out through my study. I said, the deed of trust is a smoke screen.
You're rocking with the best.
Everything that I teach in my group has been confirmed by the top professionals in this field, and it played out in my lawsuit. So my understanding is on top professional level. What do you think happens when we step inside of a courtroom with it? Yahadi further continues that the language in the deed of trust confers upon him, as the borrower, the right to sue, to assert non-existent of a default or any other defenses to acceleration and sale. Yahadi has not, however, asserted the non-existence of a default, and its only purported defense to foreclosure is that the 2009 assignment is void. Even if the language in the deed of trust might have provided Yahadi with standing to assert a defense to prevent a foreclosure, it does not help him here. Yahadi also argues that the deed of trust is an adhesion contract that does not use conspicuous and clear language to warn him that he has no power to challenge an invalid assignment of his loan. This is how it goes. From a professional standpoint, this is how it goes. They use a trust law to siphon our property from us. They use accounting to hide what's really going on. And they use contract law to stick us with the debt. Once I understood those things and how they go about doing it, then I understood that their only line of defense is the initial complaint in the attachment of the contract, in the note or the deed of trust or the auto contract. And they want to immediately try to get a summary judgment in there. And they're going to fight so hard at the beginning stages, because the longer the case proceeds, that's when their case starts to fall apart. They have no other line of defense but the contract. Wanna know why? They want to stick you and stay right on the contract. Wanna know why? It's because if they don't, they'll be exposing what's really going on behind the scenes. And it's not the fact that they're exposing what's going on, but when you understand and you also know what goes on behind the scenes, you'll understand that you never really owe what they say you owe. They never expect you to pay what they say you got to pay. And they don't even account for them receiving the amount that's stated on the contract. The contract is BS. They only expect to get a percentage of that. And that is what they expect to get for you. And that is what they go by. So anything else that you pay over that number is all extra to them. Trust me. I put this system together. And everything, I can prove it in court. See, that's the whole difference right there. No theories. Everything I say, I can prove it in court. No matter the situation. And this is why I love being the plaintiff. Now you see why I love being the plaintiff? Because I can prove everything in court. If I 15 arguments, those are my go-to. I got about 15 arguments in the chamber. And I can prove all 15. And finally, Yahadi contends that he should be permitted to amend the case to add a cause of action for wrongful foreclosure. This proposed cause of action, however, it was similarly dependent upon the allegation that the 2009 assignment is void because it was made after the ISA's trust March 2007 closing date. Because he has not led sufficient facts to establish that critical allegation, the proposed new cause of action will also fail as a matter of law. Don't even matter what you argue, it's still going to fail. The judgment is affirmed. Respondents shall recover their costs on appeal.
I'm gonna just try and break this down clearly to you. The trust in my client's case has been closed for 3 years. They cannot tie up any loose ends with that. Why? Because REMIC tax law prevents them from transferring any assets into the trust that aren't qualified mortgages and that are after the cutoff date and 90-day grace period for the trust. So they cannot tie up the loose ends. This is as clear as I could explain it to you.
And that's when I knew he was a rookie.
Sauce in my hand. She rolling the dice, got luck in that van. Smoking that leaf, going global stand. On my wrist like a stage, I can't claim. You look like you wanna let go straight. What's up? I thought so, okay. I'm back in this symphony, stuck on a band. What's up? I thought so, okay, yeah.